Hello everyone. My name is Soumya Sven. I'm an assistant archivist at the archives at NCBS, and I'm very pleased to be welcoming you all to the 51st edition of the Archives Public Lecture Series. As some of you who have attended these talks before might know, or who are familiar with our space, the Archives at NCBS is a public collecting forum for the history of science in contemporary India. It houses over 100,000 processed papers, photographs, equipments, recordings, and more. If you have time, do drop by our space. It's in the basement of ELC, right around the corner from this lecture hall. And one of our team will be very happy to give you a tour at any time. And you can also find us online at archives.ncbs.res.in. And so as a part of our monthly proceedings, the Archives runs this lecture series with talks by individuals based on their vast body of work and service. And these talks are framed around explorations in and around the field of archiving, but also broadly around the histories of ideas. The series has included discussions by artists, archivists, academics, lawyers, teachers, and others. So for today's lecture, the 51st of the series, we are very honored to welcome Chitranshul Sinha to the campus. Chitranshul is an advocate on record of the Supreme Court and a partner in Dua Associates Advocates and Solicitors. He's also an author. His book, The Great Repression, The Story of Sedition in India, was published in 2019 by Penguin India. He's also a regular contributor to publications like The Times of India, Hindu, Mirror, and Mint, where he writes on issues related to law. Chitranshul also helped draft a writ petition questioning the constitutional validity of the sedition law before the Supreme Court of India for a sitting member of Parliament. His talk today is titled Coming Apart, A Brief History of Dissent and Sedition. We will have time for a Q&A after the talk, and the discussion can of course continue over refreshments outside. Thank you so much for your time and effort, Chitranshul. The floor is yours.
Thanks everyone, thanks for coming. I know it's a Friday evening, so you guys must be missing out on some plans to be here. So like she said, I'm a lawyer and I'm an author. I wrote on sedition, and I've drafted a petition which was recently listed before the Supreme Court. And the Supreme Court has now, on 11th of May of this year, passed an order keeping the sedition law in abeyance. While the order is a good first step, it, in my view, doesn't really do much, because the Supreme Court in its order has said that the police authorities are requested to refrain from filing FIRs. And it said that if something is initiated, some trials are going on, but proceedings are initiated, then bail should be granted easily. But it doesn't really stop them from prosecuting people, from accusing people of sedition. But it's a good first step. And the government, in its stand in the Supreme Court, said that they are re-looking into the law. Now, as you know, this law is around 150, 170 years old now, 150 years old now. And it was initially brought in to control nationalist movements, Wahhabi movements. I'll be getting into all those details later. But as an introduction, in India, when around the turn of the 19th century, mid 18th century, there was no concept of sedition known in local laws, in native laws. It's particularly interesting because I personally have not found any vernacular term for sedition. If you think about it, people call it Rashtradroh or Deshdroh in Hindi. I'm sorry, I don't know other languages, but Rashdroh and Deshdroh in Hindi, and I've spoken to other friends who speak other languages, they particularly could not point out any term for sedition as such. So where does this law come from? This comes from 13th century England, and particularly around 1275. Now, England at that time was going through a lot of turmoil. The Saxons and the Celts had earlier immigrated or invaded England, the island, and the Normans came later. And in the 13th century, the Norman kings were ruling England, but the Saxons had a lot of conflict with Normans. Even though the king, Henry III was the king then, he was not really a strong leader. So there actually were events like throwing of stones at his queen while she was commuting to and fro from the palace. There were people openly singing songs, like explicit songs against the king. And this was not being controlled under any law. So when his son came to power, King Edward I, he made it an offense to slander the crown. And this was done at the first statute of Westminster. This was sort of the first Assembly of Westminster, was sort of the first informal parliament in all of England. And the first statute of Westminster was passed in 1275. And it just sort of said, don't abuse us, don't defame us, don't slander us, don't say false things about us, respect the crown. So the origin of the sedition law comes from the need to protect the crown. He was not a democratically elected leader. He was a monarch. Monarch needed protection. Interestingly, this law, the Statute of 1275 had the provisions on sedition. This was repealed only in 1887. So it's continued for a good 600 odd years. And in the meantime, there was also, this is an interesting concept there, as in there is this thing called star chambers. And what they essentially did was, they went after political libel. But there was no rule governing it, no statute governing it. And these were secret proceedings where they rounded up people and just penalized them for speaking against the government. So there was a lot of pushback. And then in 1792, before this other statute was repealed, there was another law called the Libel Act of 1792, which prosecuted seditious libel, which incited crimes against the government. Now, there was no term called sedition even in the original statute or the subsequent statute of 1792. They referred to the offences as seditious libel and seditious conspiracies. Seditious libel, as you know, is like defamatory statement against the government, and conspiracies would be acts against the government, trying to overthrow the government. So this was eventually, this libel act also continued for a long time. But this law came to India much later. And to understand that, we first need to understand how India got an IPC, the Indian Penal Code. Now, as you know, India originally had the East India Company before the British government. And the first factory, if they call it a factory, but it's because the people who worked from the factory were called factors, who were responsible for negotiating trade deals with local merchants. So it was called a factory. The first factory came up in Surat in 1613. And the English employees were subject to two legal systems then. One was on the ground. English laws were applied when disputes arose between the employees of the company. And then there was the martial law, which was applied when something happened on their ships. As far as the natives were concerned, I mean Hindus, Muslims, all that religions, the natives were concerned, they, when they had disputes with company employees, they used Hindu and Muslim laws to adjudicate upon those disputes. So English law was restricted to the employees of the company. Now, after Surat, the first factory was also, the first factory in southern India was established in Madras in 1639. That is where the Fort St. George was built. But it became a presidency only in 1653. Earlier, the eastern coast was controlled from Indonesia, from Java. So the seat of the presidency for the eastern coast of India was in Bantam in Java. But eventually they moved the presidency to Madras, which was in 1653. After that, the Bombay presidency was created when they moved the seat of the western coast presidency from Surat to Bombay. And this actually, it's called the Bombay presidency. It started from Sindh and it literally went up to Karwar, almost up to Goa. It was that huge a tract of land which was under the Bombay presidency. And in the east, in Bengal, the first factory was built in 1640, but the presidency finally came only in 1765. There were many conflicts with the Mughals and the French, so they never could establish an absolute rule over the Bengal provinces in Bengal. So that eventually only happened in 1765. And this was when the company actually transformed itself from becoming a trading corporation as such into a territorial power with military might. Now, to control these presidencies, now they had 3 large tracts of land, large regions to govern. So they came up with rules of law, they came up with new judicial systems. Now, as far as civil law is concerned, the natives governed themselves, Hindus were left to their own laws, Muslims were left to their own laws. But when the British came, they started applying Hindu law to civil disputes. For Hindus, Muslims were governed Muslim laws for Muslim disputes, but when it came to offences, prosecution for offences, they used Muslim law for that. They just ignored Hindu law, they just applied Muslim law for that. But there was no uniformity, because large portions were still under princely states, a lot of area was controlled by zamindars. They just applied the law the way they wanted. There was literally nothing, that was not consistent at all in the application. Now this change started with the Bengal Presidency, which established a judicial system where English laws were applied to the British subjects, personal laws were applied to the Hindus and Muslims, and later this system was extended to Bombay and Madras Presidency in the early 19th century. There were laws called regulations, Bengal regulations, Madras regulations, Bombay regulations. All 3 had separate systems altogether. There was absolutely no consistency there again. And so, and earlier in 1784, the British had created a council to control the affairs of the East India Company in India, because they had grown too big. The Crown wanted to control it. And after that, they tried to compile a civil law for Hindus by going on the scriptures, but they realized that there are too many scriptures to look into, and they could not actually succeed at this task, so they just gave up that process. And by the early 19th century, criminal justice system was completely governed by British regulations. They again gave up Muslim laws for criminal justice systems also, so they completely had British regulations there too. But these regulations had absolutely no linkage with any native law. It was just, they used English common law. So common law is a system where the law is actually not derived from statutes or from acts, written acts. It's derived from a system of judgments which the courts give. They use equity and good conscience to give certain judgments where there's a vacuum in law. That's called the common law system, and that is the basis of the creation of the regulations. Now, English laws themselves at that point of time were not codified. There's largely lab codification, they're still not codified. But Bentham, as a proponent of codification, tried to do that in England, he failed. He went to France, he tried to do that. His disciples, or rather his followers, his students, they brought it out, and he's the one who termed the term codification. Now, what is a code? Now, if you look at a bookshelf, the books themselves per se are the laws in a particular category. The shelf containing everything together in one place can be considered a code. It's just basically putting everything in one place for certainty in law. So the first attempt at codification in India was made by the British in 1833 under the first law commission, which was led by Thomas Macaulay. He was a law commissioner. There were 4 other members. There was MacLeod, Anderson, Millett and Cameron, but unfortunately for Macaulay, none of them contributed to his efforts to codify anything in India. 2 of them were sick, one was never in India, and one came to India for a little bit, but he left. So Macaulay, in fact, single-handedly started drafting the penal code, and he started in 1835. Now, the draft code itself completely again disregarded all native laws, all native systems, because he said everything is inconsistent. I can't focus on one system to use it. Everything was inconsistent, so he completely ignored that. But he relied on the French penal code and on the penal code of Louisiana. This is what he refers to in his notes on the penal code that he had made. And this French code of Louisiana also based on the penal code of Louisiana also based on the French code. He drafted this and he submitted it to the Governor General in 1837. That was when the draft penal code was submitted. But it was not acted upon. The government said we need to look into it again, we need some certainty, we need some revisions. In fact, there was a rival penal code by G.B. Bethune around 1849. He came up with the rival penal code. But that itself died because he made it so harsh, so stringent, that even the British were not interested in imposing it. So they completely ignored it. And this penal code, Macaulay's draft penal code, was revised but again not implemented. In around 1854, the British government said this needs to be implemented, but nothing was done. They were just sitting. All of this changed in 1857 when the revolt happened. After the revolt, the Crown came to power. They replaced the East India Company completely. And they realized that they need a penal code. So around 1860, this Macaulay's draft with certain revisions was enacted and came into effect in 1862. 1862. Now Macaulay's draft had a provision creating offence of sedition. It does not itself call it a offence of sedition, but there was a offence which was later revised. It was section 113, rather clause 113 of his draft code. That, unfortunately for the British, fortunately for this country, it never made it to the penal code of 1860. Now, there was a discussion, or when it was eventually introduced in 1870, there was a discussion that why wasn't it made a part of the original code. They said it was oversight, we just missed it. It was a mistake on someone's part, it just didn't make it to the code. Now, this came on the statute books only in 1870, 10 years after the introduction of the Indian Penal Code. The most proximate reason for introducing this section into the Penal Code was the Wahhabi movement. And there was this movement stretched across the plains across the northern plains from Patna to Ambala. There were conspiracies. So they eventually landed upon a conspiracy where arms and ammunition were being supplied from Patna to Ambala to fight the British in the northwest frontier provinces. So they realized that this needs to be brought in, and this was the most proximate reason for bringing the code into effect, bringing this provision into the law. Now, even though this was introduced in 1870, it took 21 years for this law to be actually implemented. The first trial under this provision only happened in 1891. This is called the Bongo Bashi case. It's very interesting because this case is actually called Queen Empress versus J.C. Bose. He was the editor of a Bengali weekly called Bongo Bashi. The trigger for this was the Age of Consent Act of 1891. At that time, the age of consent was, the original age of consent was 10 years. There was nothing stopping, men from consummating the marriages with child brides who were as young as 10 or even younger. The British government in Bengal wanted to raise the age, not by a very large margin, but from 10 to 12. But this was seen as an affront to Hindu culture, the native culture. Bongo Bashi wrote articles attacking the foreign government. They said the invaders have come in, foreigners have come in, and they are completely destroying our culture. And they published articles opposing the act and articles saying that the British government has no role to play here, the British government are invaders, foreigners and all that. So they were prosecuted, the editor was prosecuted for this. This was the first time when Section 124A was actually interpreted. Justice Petheram of the Calcutta, Supreme Court of Calcutta, he interpreted this provision extremely strictly. When Section 124A was being introduced by Stephen, he had actually envisaged that this would only be applicable where there is cases of public disorder or violence. But Petheram, in his judgment, in his charge to the jury, who were hearing the case said that even if there is no violence, the only test is disaffection and disapprobation. Basically, disloyalty and hatred towards the government. Does someone, by writing something or speaking something, want to create hatred or disloyalty against the government? It's sufficient to punish them under section 124A. That was the only requirement that he said. This was contrary to what Stephen had said. This matter itself ended in a mistrial, sort of a mistrial, because there was no majority, there was no unanimous verdict on this. And later the prosecution didn't press the case. So the second time it was tested was in 1897 at that famous trial of Balgangadhar Tilak. What had happened here was, there was a plague in Pune, and the British government tried to control the plague like with force, with martial force in fact. And they started taking people out of their houses, throwing them away, burning houses. That's the way they were trying to control the plague. Tilak was quite instrumental in trying to control the outcomes of this. He's trying to help people there. And at the same time, he used to run a paper called the Kesari. The Kesari published some speeches that he had delivered in Raigad at a function, a festival celebrating Shivaji. He had made statements basically justifying Shivaji killing Afzal Khan, saying that Afzal Khan was a foreigner. If a foreigner comes to a land, forget the law, forget everything, you are supposed to kill the foreigner, kill the tyrant. And various other similar speeches were made, all of which was published in the Kesari. Immediately after that, Rand, the commissioner of Pune, was assassinated by one of the Chapekar brothers. The British government took his speeches as an incitement for this offence and accused him of sedition. What Tilak's defense was essentially that what I wrote, what I said, number one, has nothing to do with the crime itself. Number two, it was an all-English jury. He said, you do not understand the import of what I have tried to say there. This has nothing to do with killing anyone. But the court again reiterated what Justice Petram had said in the first trial. The court told the jury, you have to stick to this. It is sufficient that he is sort of implying that you have to fight the British. And it appears, even though they could not prove any link, that it appears that his speeches have caused assassination. So he defended his case very strongly. He was not able to find lawyers to defend himself. 2 lawyers from Calcutta came to Bombay to defend him. But eventually he was sentenced to prison. Thereafter, there were 2-3 other trials which sort of deviated from what Stephen had said, and they again used what Strachey-Rowley said. So the government thought it would be prudent to actually amend the law itself. So in 1898, there was an amendment which completely ignored why the law was originally included in the IPC, and it re-emphasized that mere incitement or disloyalty was sufficient for imposition of section 124A. Now, this law kept being used against nationalist movements, which actually started in more gusto around 1905 when the partition of Bengal happened. It actually started a wave of revolutionary crime, mostly in Bengal. People were up in arms against the partition, and it was actually a political move in the sense that they wanted to destroy Bengali unity, the Hindu-Muslim unity. And there were newspapers there which were militant nationalist newspapers, like the Jugantar. Jugantar was prosecuted 5 times for sedition. Eventually they had to shut shop. It became so bad for them. Every time they would write something, they would prosecute it. So, and this was not the only law which governed sedition. The British also brought in the Seditious Meetings Act in 1907. Basically, it was a preventive law, which simply said that if there could be a meeting which could result in seditious activity, it's banned. There was a Dramatic Performances Act, again the same thing. You cannot have a performance which incites disaffection against the government. There was a play called Chai Ka Darpan, and it was about rights of tea workers in the plantations in Bengal. They were being oppressed by the British masters, and they just wrote a play about it. It was banned under the Dramatic Performances Act for being seditious. Similarly, there was, and after the Seditious Meeting Act and everything, there was a committee which was formed to review revolutionary crime in India. It was called the Rowlatt Committee, and they basically went through all revolutionary crime records of all sorts of crimes in India which had occurred because of the Gadar movement, the Bengal partition, and they eventually came up with the Rowlatt Act. And they wanted to make the criminal law even more stringent. Basically, the law provided for preventive detention and punitive detention without any trial, no special courts, no lawyers allowed, and a very draconian act. It was called the Rowlatt Act. It has a very long name, the Prevention of Anarchical Offences and whatever, but it was called the Rowlatt Act. Some people call it the Black Act, the Dark Act. And there was a huge protest against this act in India. Now, this Rowlatt Act is very important for our later discussion on UAPA also, because the Rowlatt Act had a built-in safety valve. The act could only be applied if there was a declaration of emergency. There has to be a proper declaration of emergency saying that revolutionary crime, nationalist crime needs to be stopped. There was exigent circumstances, so this act is being imposed. Without that notification, the act could not be imposed. And this act, in fact, was never used. It just died a natural death. It was never used. One very unfortunate thing that came out of this act was Jallianwala Bagh. That meeting was a Vasant meeting, but it was also a political meeting protesting the Rowlatt Act, where Dyer opened up fire and killed, massacred people. Now, after all this, after 1919, it was actually, this provision was actually used to make a political statement. This was done by Gandhi, Azad, Nehru. So after the Rowlatt protests, the Khilafat movement started in India in 1920. Gandhi's non-cooperation movement was also going on. He combined the two movements. Gandhi became a thorn in the side of the British. Then he started the civil disobedience movement in 1922, which was immediately called off because of the Chauri Chaura incident, where locals burnt up the police station in Chauri Chaura and killed all the police officers, Europeans and Indians alike inside the station. He immediately called it off. The British thought it was a good opportunity because Gandhi's on the low, let's just arrest him, let's just prosecute. Gandhi was arrested in 1922 and he was accused of sedition for writing certain seditionary articles in Young India, which is a paper that he had founded. Mahatma Gandhi did a very unique thing. Earlier, it is distinct from Tilak's defense, because Tilak said that he was not guilty. The law did not apply to him because the acts that he was accused of did not actually fall within the definition of sedition. Mahatma Gandhi did something different. He said that it is my duty to be seditious and I don't recognize your law. He said this is a foreign law, this does not apply to us. He said, I'm pleading guilty. If you think I'm seditious, then I'm seditious. I'm pleading guilty to it. You do whatever you want to do. You send me to jail. I'm not going to apologize. I am seditious. And he, in fact, during his that non-defense, said that 124A is the prince among political provisions of the IPC. His entire trial lasted 100 minutes. That is it. And he was then sentenced to prison, but he was released in fact, the magistrate told him that, please apologize, say you won't write anything, won't do anything, I'll just immediately release you. He refused to do that. He was sent to prison, but was immediately released. Nehru used the same strategy when he was arrested later. Nehru did it twice in 1930 and 1934. Again, he went 1930 and 1934. Azad did the same thing. So this was how they actually used this provision to make a political statement. Like, we are not fighting it, we are saying it doesn't apply to us. Now, these are just very few instances of prosecution of nationalist figures or politicians under this law. There are hundreds and thousands of such examples that I really don't want to get into because it will take us the week to get through all this. But an important change came around the time when the Constituent Assembly was formed. Just a little prior to that, in 1942, there was a case of Nirendu Datta Mazumdar, where Justice Maurice Goyer of the Federal Court actually interpreted 124A as it was originally intended to be. He said it's not sufficient that someone's uttering or writing something which may cause disaffection. It must incite or must have the tendency to incite violence or public disorder. The Privy Council immediately overruled this judgment. And in 47, there was another judgment. This was a judgment by Privy Council which overruled it and reinstated the original position that there is no requirement of violence to be carried out subsequent to your utterances. 6 months after this, India became independent. After the second judgment, this judgment was called the Sadashiv Narayan Bhalirao judgment. The Constituent Assembly had this Fundamental Rights Subcommittee. This was headed by Patel. And in April of 1947, Patel introduced his draft report on fundamental rights. This draft report provided for restrictions on fundamental rights on the grounds of sedition. This was strongly opposed by a member of the Constituent Assembly named Somnath Lahiri. Somnath Lahiri essentially said that this report, the fundamental rights, are being framed from the point of view of a police constable. And he attacked the restriction on free speech, saying that what's been used against us over the course of the time, over the course of a century, is now being included in the fundamental rights as a restriction against your own citizens. Patel withdrew this restriction. But in 48, it came back again as a restriction on free speech. That time it was strongly opposed by K. M. Munshi. K. M. Munshi wanted the word sedition dropped completely as a restriction. He was supported by Sardar Hukum Singh, Thakur Das Bhargava and Seth Govind Das. Interestingly, Seth Govind Das was prosecuted for sedition because his father had been awarded something by the British for his gallantry and for his loyalty to the government. Seth Govindram Das, on the other hand, was a nationalist politician. He said it's a sin for my So Govindram Das said that this is a sin for my father to have accepted this, and now I discard it. For that he was prosecuted for sedition, simply for saying that. So it's something that has been used against me, against so many fellow citizens. We cannot have that as a restriction on free speech. So this term particularly was dropped as a restriction, which eventually became Article 19(1) and 19(2) of the Constitution. But 124A itself continued to be on the statute books. After independence, the first challenge which was made to this came via a judgment of the Punjab High Court in 1950. The High Court simply said that Section 124A had become void as it was in contravention of Section 19, freedom of speech. So it had become completely void. Immediately after that, the Constitution was amended. The first amendment in 1951. It protected the state's power to provide reasonable restrictions on free speech in the interest of public order, security of state, friendly relations with foreign states, and to prevent incitement of offences. Interestingly, while this was being debated, Nehru called section 124A as an obnoxious provision, which does not deserve to be a law in India. But despite that, it was still continued. It was never repealed. Even then, it was not repealed. After this constitutional amendment, there was a second challenge to the provision. This was a 1954 judgment of the Patna High Court, which said that because of this amendment now, which was made retrospective, as in it had come into effect the day the constitution came into effect. So they said that 124A would not be constitutionally invalid because it's now protected as a reasonable restriction on free speech. After that, there was a third challenge. This was a 1954 judgment of the Manipur High Court. It partially held 124A to be constitutional. It said to the extent it simply punishes free speech, it punishes political speech, it is unconstitutional. But if it goes on and incites violence and public disorder, to that extent it is constitutional. So it just partially struck down 124A but partially saved it. Then there was a fourth challenge. This was the Allahabad High Court judgment of 1958, which said section 124A is not a reasonable restriction as it doesn't say anything about public order itself. Because while the restriction talks about public order, the section doesn't talk about public order. The section simply says utterances of words which may create disaffection, disprobation, disloyalty. So it does not say, it does not have public order words in the text. So the Allahabad High Court said that therefore it's not a public, it has nothing to do with public order, so it's unconstitutional, it's not protected by this restriction. So it declared it unconstitutional. Finally, in 1962, this question was settled by a constitution bench of the Supreme Court. It's a 5-judge bench of the Supreme Court. This was a case of Kedarnath Singh versus State of Bihar. Kedarnath Singh was a communist, and he made utterances like the dogs of CID are around, roaming around, trying to arrest us, keeping, as in surveilling us. He was prosecuted for sedition along with a lot of other people. The cases eventually reached the Supreme Court, which culminated in judgment of 1962. The Supreme Court, in an effort to save the law, it read into the law the public order test. Even though that is not in the text, the Supreme Court read that into the text of the law and said that 124A would only be attracted if words written or utterances had the tendency to or incited violence or public disorder, and to that extent it would be a reasonable restriction on freedom of speech. So by doing that, they created a test that when you're prosecuting someone for sedition, you have to see whether that actually has an effect, a real world effect. Simply making political slogans may not lead to violence, so it may not be sedition as the law says or as judgment said, but it has to lead to violence or has to incite violence or have the tendency to do so. Now this is the position of law as it stands today. This was followed by the Supreme Court in Balwant Singh. This was on 31st of October 1984, when the day Indira Gandhi was assassinated. After assassination, two gentlemen, Balwant Singh and Bhupinder Singh, in Chandigarh started raising pro-Khalistani slogans. Khalistan Zindabad, Hum Azadi Honge, and things like that. They were arrested, as it was expected, they were arrested. When the case finally reached the Supreme Court, in 1995, the Supreme Court said that merely raising of slogans which did not cause violence would not attract Section 124A. And the court lambasted the police officers and the magistrates and everyone involved in the conviction till date that even after they raised these slogans, there was nothing real world, there was no real world impact of it. There was just two people randomly raising slogans. How is it sedition? In fact, there was another case, Bilal Ahmed Kalu, who was alleged to be a member of a jihadi outfit, and he was encouraging people to train themselves in arms. And then there were blasts in Hyderabad in 1993. he was accused of sedition. The court, Supreme Court acquitted him. Said that no case have been made for sedition has been made. He may be guilty under a lot of other things, but no case for sedition has been made out. Just because he is a member of an outfit or encouraging people, nothing. There's no evidence which suggests that he is directly linked to the bomb blast. So how can you convict him of sedition? In fact, in 2011, this is the Binayak Sen case, the famous Binayak Sen case. He was arrested for sedition for being in links with a Maoist and having Maoist literature at his house. His bail was restricted by Chhattisgarh High Court. He came to the Supreme Court. Supreme Court granted him bail and said no case for sedition is made out even when merely if a person is member of a Maoist organization or he has Maoist literature. No case is made out simply merely for these reasons. There has to be a larger role that he plays in inciting violence or causing an uprising against the government. He was granted bail. This was just a case for bail. Now this position of law is now under challenge. This position of law is under challenge, this new judgment which I just talked about. This is SG Wombat-Kere versus Union of India. Unfortunately, at least this is my personal view from what I've seen in court, there was a difference of opinion between the Attorney General and the Solicitor General. Attorney General said this needs to be looked into. This needs to be considered. Whether the government wants to make a change or not, we need to look into this. The Solicitor General, Attorney General was appearing through VC. Solicitor General was in court, and we could see the Solicitor General shaking his head like this. And he said, no, the Attorney General has his views in his personal capacity, not as the Attorney General for India. I am appearing for the central government, and I am saying that while we are relooking it, we are not going to make any comments on the law. But the court said that fine, now that you're relooking into it, let's just keep the law in abeyance. The government stand is that Kedarnath Singh is the law. You cannot disturb this law, it is good law. And this matter is being right now heard by a 3-judge bench of the Supreme Court. But the Kedarnath Singh judgment is a 5-judge bench judgment. So it says even if the court wants to interfere, it has to constitute a larger bench. And I personally don't have too many hopes, because in 2019, just before the election, when Congress came out with its manifesto, said that they wanted to repeal the sedition law. Rajnath Singh made a statement that Congress wants to repeal it. We want to make it even more stringent. He said, I want to make the law such that it sends shiver down people's spines. So it does not give you a lot of confidence when the government says they're relooking at the law, and then outside the court your politicians are making such statements. So one is not too confident. I don't know about others, but one is not too confident about what's going to happen to this law. And recently, this law, it's just reached a very ridiculous stage. While the Supreme Court in Kedarnath laid down the public order test, it did not define what that is. It is not defined in the law, it's not defined anywhere. What is the public order test? Now, for example, you go out and start raising slogans against the government, and because of that, some vandals are part of your group. They approved few chairs from the park. They want these steel chairs, nice chairs, they approved chairs, lamps, take bulbs away. Is that public disorder? It may be. Is that seditious? Because there is no test. Was there violence? Yes, there was violence. Was there public disorder? Yes, there was public disorder. Does this threaten the integrity of the country? No, it does not. But it does not stop the policeman of the local police station from filing a FIR under section 124A. There is a safety valve which I don't think is sufficient built into the Criminal Procedure Code. This says that before any magistrate can take cognizance of the offence against a particular person. So taking cognizance means charges are framed against a particular person who is accused of sedition. Framing of charges is a very it's a formal procedural step. it happens after investigations are carried out by the police. So section 196 says that to prosecute someone, for a magistrate to take cognizance under section 124A, there has to be a prior sanction from the state or the central government, as the case may be. So, but this only exists at the stage of charge sheet, what we call charge sheet in normal parlance. This only happens at that stage. There is nothing stopping the police from simply arresting people. The stage of charge sheet and investigations, there are some criminal lawyers sitting here who can tell this better, reaches like, one doesn't know when that stage will ever reach. And this provision is used majorly against marginalized people. They do not have the resources to fight a legal battle. Simply getting bail in a country like India, it sometimes feels like that we are asking the magistrate to give bail from his own pocket, like he's supposed to pay the bail bond and he's supposed to go personally release the person. They act in such a way that it feels like it's a huge task. The bail being a rule and jail the exception has actually been reversed in reality. So magistrates don't easily grant bail. Even if bail is granted, people may not have the wherewithal to provide security to get such bail, to provide bonds. They may not have sureties. So a person will be fighting this battle till the time the stage for charge sheet reaches, and that is the time when the prior approval is required, prior sanction is required. But in majority of cases, 80% of cases doesn't even reach that stage. Forget acquittal, forget conviction. At the time that I was writing the book, I was speaking to someone, very high-ranking police official. He was helping me with my research. And the Home Ministry in the Parliament had made a statement that there have been 2 convictions for sedition during that time. I'm talking about 1819 period. So one was in Jharkhand and one was supposed to be in Telangana. I asked the policeman to find me this proof of this conviction, because I could not locate it anywhere. He sent a message to the local SP where this case was supposed to have been tried. The local SP asked him what conviction. So then he sent a constable, the SP sent a constable to actually check on the ground that whether there has been a conviction or not. I think you still hear me, right? Am I talking too loudly?
Yes, yes.
So the constable actually made a report back to the SP that even he couldn't locate this conviction. We couldn't find anything. I found one order of bail in some case, but he could not locate anything else. So I asked him, then how is this that it's reported that there's a conviction for sedition? He said, we have no idea. The second case in Telangana, again he spoke to his batchmates in Telangana, they could not locate it. Now I don't know whether it happened or not. I could not find the judgment, the conviction. And I sent the people to the ground level to find it, they could not locate it. And the reporting on such offences is very inaccurate. The severest offence that one is accused of is recorded by the the NCRB, which records crime in India. They come out with these reports, crime in India. So offences against the state is a category. They started recording that in 16, 17 as a separate category altogether. And they report a certain number of cases as being FIRs under section 124A. So I asked him, how is this created? He said, so it's recorded on the principle of the severest offence. So there may be a case that there's a murder and as well as an accusation of sedition. So it does not get recorded as accusation of sedition. It only gets recorded as a murder. So while whatever is reported, the numbers, I anticipate the numbers to be much higher. And especially over the last decade and a half, use of this law has really increased. Since 2010, there have been 11,000 such cases which have been filed, and the conviction rate is 0.87%. It's not even 1%. Most of these cases die before the charge sheet level is reached. They're very weird cases. In 2014, there was an India-Pakistan match. Afridi really played well that day. We lost. There were Kashmiri students in Meerut who started celebrating this. Now there are political reasons behind it, right or wrong, whatever it is. They were arrested and charged for sedition, simply for celebrating the win of the Pakistani cricket team. The charges were eventually dropped, but they remained in jail for a couple of weeks. It was only after the intervention of the Chief Minister of Jammu and Kashmir that the UP government dropped those charges. In 2012, this is cartoonist, now he's become famous, I'm sure not for his art but for this case, is Asim Trivedi. He made cartoons showing the government in a very bad light for his website called India Against Corruption. He was arrested, he was in jail, charges were dropped, but the Bombay High Court didn't let it go, and it came out with a judgment in this case. And the judgment is interestingly by Justice D.Y. Chandrachud when he was sitting in the Bombay High Court. He's now the Chief Justice of India. This challenge against the sedition law is now going to be heard by a bench led by him. So it becomes very interesting in that sense. And he also made a very interesting statement at one of his lectures, these lectures that these guys are now giving everywhere, where they're asserting fundamental rights and civil rights, but different things happen in court. So he gave a very nice statement, beautiful statement, which I used for my book, which he said that the Constitution weeps when a cartoonist is arrested for sedition. That's what he said. So in this judgment, he reasserted the principles of Kedarnath Singh. He said, talked about violence, that obscenity and vulgarity can't be sedition, which is supposed to be a no-brainer, but the policemen don't think about these things. And he created guidelines where he said the law officer of the district plus the public prosecutor have to provide a legal opinion before anyone is prosecuted for sedition. Unfortunately, this judgment only applies to the state of Maharashtra. It doesn't apply outside. So there's no standard for this across India now. In 2016, the Supreme Court had a great chance to do something about it, maybe create guidelines, water it down. When the Kudankulam protests were happening, about 8,956 people were accused of sedition, simply to stop the protests against the nuclear plant. The matter reached the Supreme Court. Supreme Court simply said, no, Kedarnath Singh is good law. Apply Kedarnath Singh. We don't want to say anything further. Apply Kedarnath Singh. The local policeman is not going to sit and interpret a Supreme Court judgment. 8,956 people. Many of them remained in jail for a very long period of time. Many of them lost employment, lost their livelihoods. And there are no consequences to that. The government doesn't care, the police doesn't care. In fact, the Inspector General of Tamil Nadu, which was a hotbed of sedition cases, because there was another protest going on in Thoothukudi against the Sterlite factory, again thousands of people arrested. He said that this provision is a scare tactic. He said we do this to scare people on the ground, scare activists on the ground. We want to stop them from doing something. We are using it as a state scare tactic. This was also repeated to me by a policeman in Jharkhand. There was a movement in Jharkhand also around after 1670 called the Patalgadi movement. The government was amending the local land laws to enable tribal land to be used for purposes other than agriculture and for non-tribal purposes, which was particularly barred. And this law could not have been changed without consent from the Gram Sabhas. There was a huge movement, huge land rights movement. Patalgadi is essentially means a large column of stone. Tribal societies in Jharkhand use this to mark the boundaries of their land. What they did was they planted these stones, they wrote down the provisions of the constitution on it. and said, and then there was a violent movement. There's no doubt that there was a violent movement, but it was triggered by the rape of a tribal woman who was a land rights activist. Again, thousands of people accused of sedition. These charges were eventually dropped when the government changed. When Mr. Soren came to power, all these charges were dropped after that. Now, in 2015, in fact, Arun Jaitley, who was the law minister of the country, he criticized a judgment of the Supreme Court which struck down the NJAC. This was a commission created for judicial appointments. And the Supreme Court struck it down, saying it goes against the basic structure of the constitution, it interferes with the autonomy of the judiciary. He criticized it. He called it the tyranny of the unelected, something on those lines. This magistrate sitting in Mahoba in Uttar Pradesh took upon himself, there was no complaint before him, he took it upon himself to initiate a sedition prosecution against Arun Jaitley. And this was eventually quashed by the Allahabad High Court. They said, what is this ridiculous case against a person for criticizing a judgment? He said it's seditious to criticize a judgment. And if the Law Commission had its way in the 1970s, the Law Commission recommended that criticism of the legislature, the judiciary and government officials should also be brought within the ambit of 124. And thank God nobody acted on it. The last Law Commission report just prior to the one which has been constituted now recommended a relook into the sedition laws. Quite a progressive report by their standards, but again it was sent to cold storage, nothing happened. Now a new commission has come in and again we have no hopes from this commission. I don't want to say my reason, but I have no hopes from this commission. So as you can see, this law, and again it was used against the protesters, CAA protesters. And with these protesters, especially like places like Assam, Manipur, they were simply thrown in jail for criticizing the CM, criticizing the act. This was used on a very large scale level in Delhi, but the hotbed was Assam. And someone put a Facebook post criticizing the CM and called him a tool of the BJP, or something like a tool of the Hindutva agenda or something to that effect. He was immediately arrested. But surprisingly, and why I call it this surprisingly, because like I said, magistrates don't like granting bail. A magistrate sitting in Imphal said no case seems to be made out prima facie and released him on bail. And while this should be the rule, it was such a shock to me that a magistrate is granting bail in such a case while sitting in the same state. These are like small acts of resistance as far as I can see, because civil rights, fundamental rights have to be enforced at the lowest of levels first. The Supreme Court and the High Court should not be the protectors of fundamental rights. It's the lowest court of criminal magistrate which should be doing it. Because punishment is in the procedure. Like I said, 0.87% conviction rate. One may never be convicted for any such offense, but that entire procedure itself is the punishment. One of the challenges now to this provision itself is, number one, Kedarnath Singh was a wrong judgment. It tried to protect a provision from being declared unconstitutional by watering it out and reading into it certain things which were not present in the act. Number two, this act, this provision itself is manifestly arbitrary. When the British government was using 124A, the imprisonment provided under 124A was transportation for life outside the territories of British India, transportation for life, or imprisonment for 3 years and or fine. So 3 distinct penalties were provided under the law, under 124A. Now after independence, there is no question of transportation outside the territory. That's not a punitive measure under the Act. So this is something that we do in Word documents. We do Control F and replace, right? So the government did a Control F and replaced. They converted transportation also into imprisonment. So now the law says that a person can be punished by imprisonment for life or imprisonment for 3 years. and or fine. Three distinct penalties provided in the same provision. So that is another leg of the challenge, at least in the petition that I drafted, that this is manifestly arbitrary. How does one decide whether to give imprisonment for life or for 3 years? This is so broad that you're leaving it in the hands of the trial court to do whatever they want to do, to the whims and fancies. Another challenge is, and this is a slightly uncomfortable challenge, that this provision overlaps with provisions of the UAPA. UAPA is Unlawful Activities Prevention Act. It was enacted in 1967. And it mirrors what section 124A says, and it brings it into UAPA as an unlawful activity. And there it provides a penalty for imprisonment for 7 years. So identical provisions in 124A and UAPA, imprisonment of life, 3 years, fine and or fine. Then under UAPA, similar provision, imprisonment for 7 years. So the same field is occupied by two laws. Umar Khalid recently got bail under 124A, but is still being prosecuted under UAPA. So this is another ground of challenge that we made, that this again creates arbitrariness. Now, after Rajnath Singh made this statement in 2019 that they want to make this law even more stringent, in 2021, the Home Ministry set up a 5-member committee to review Indian criminal laws. What they said was that our laws are legacy, they are colonial legacies, they are rooted in a time where the British wanted to oppress our people. So these laws need to be changed. At the same time, you read it along with the Rajnath Singh statement, so one doesn't know where this is going. This 5-member committee has no representation from the minorities, from marginalized communities, from women, from civil rights activists, from the judiciary. There is absolutely no representation. So we are actually repeating mistakes of the past. What we are criticizing is what we are doing ourselves. We say that the British government framed laws in a particular way. There was no representation there. 4 Englishmen decided to draft this code for you. They are repeating the same mistakes by having a 5-member committee of Indians, but with no representation. And in 2022 January, the Home Ministry has now written to the CJI, to members of parliaments and all the chief ministers, asking for their views on changes in law, Criminal Law and Evidence Act and CRPC, the Criminal Procedure Code, and IPC. So now we are in a situation we really don't know where this is going. There's no public deliberation. I don't know whether deliberations actually happened or not, but there's no public record of any such thing happening. We hope it goes to a public consultation level, but going by recent examples, the government is not too keen on getting public consultation on important aspects of law. So we really don't know where it's going. And the country which actually gave this law to us repealed it in 2009. The only exception it carved out was that seditious activity would still be punishable if it was done by a foreigner, an alien in England. This was repealed even by New Zealand in 2007. Like a lot of these Commonwealth countries, wherever England had their colonies, they all had sedition laws. Like in India, Pakistan and Bangladesh, all 3 have section 124A, which provides for the offence of sedition. And India and Pakistan are the countries which weaponize this law the most right now. Australia in 2010 watered this down again. They removed the reference to sedition, but it's not really help. It doesn't really help because they say that any incitement to violent offence would still be punishable. So it could be anything. This law was repealed completely by Scotland in 2010, by Indonesia in 2007, because it was a vestige of their Dutch masters that this law was left there. They again repealed it in 2007. South Korea repealed a similar law in 1988. Ghana repealed it in 2001. Spain has a similar law. Spain, and right now with the movement for Catalonia, about lots of activists were punished and they are looking at 15 years in prison for their sedition law. And now in November, as late as November 2022, they've decided to have a relook into the laws, despite what is happening in the country. The question that needs to be asked is, why do we need this law today? Is our democracy, is our state so brittle that a student giving a lecture, like I'm doing this, someone may be giving a lecture somewhere or some speech somewhere, can it break the country? Can it destroy the integrity of India? Because sedition in itself should mean that it has to be something which has actual potential to overthrow the government of the country. And there was a very interesting argument raised in these petitions in the Supreme Court recently. Kapil Sibal made this argument that the state is distinct from the government. This is an offense against the state. The chapter under which this law, where it is written, is a chapter which provides for offenses against the state. It doesn't say offenses against the government. Now, obviously this was not discussed because the court wanted to pass an interim order. But it's a very interesting concept because treason is also provided for in the law. There's an offense of waging war against the state. There are offenses which provide for penalty for destroying public property, for murder, for causing grievous hurt, all sorts of violent activities, injuries to the body, injuries to public property. Then why do you need this law? You can always punish people for under these other provisions. Why do you need this law? UAPA again is debatable. UAPA, there are other challenges to UAPA. But till the time UAPA is there, why do you need this law? Why does someone get prosecuted for the offense of sedition when someone criticizes the army? The army has broad shoulders. The army can take that criticism. The question that all of us need to ask is, why do we need this law? There needs to be a targeted advocacy that while the government is looking at this law, at criminal laws, do away with draconian provisions. Do away with this bogey that people criticizing the government or asking for a change of government. Why any such thing can bring down the country? It cannot. You need laws in states where there is some internal insurgency, but there are laws to deal with it. And even the worst of laws like the Rowlatt Act had that inbuilt safety valve where it says that only on imposition of emergency, notification of emergency, this can be imposed. There's no such thing exists in 124A. There's no safety valve. So in short, basically, all I'm trying to say is that when you talk to each other, when you speak to people, you have to advocate for this law to be repealed altogether. Because otherwise, it's, in a democracy like ours, it does not belong in this country. So that's all. Thank you.
Thank you so much for this talk, Chitranshul. If any of you have questions or comments, please raise your hands so we can pass the mic to you.
Hi, very interesting talk. So I was wondering about, so you mentioned how the Section 124A had constant opposition by Nehru, by other freedom fighters, and by other high courts as well. So I didn't quite get what's the other side. What is this other side which is actually pushing for keeping it there? Because there is clearly another side, and what's that side, and what's their motivation? What do you think?
Political convenience. Every single political party would want such a law to exist. You never know when they will need it. While today you may have thoughts about a particular government weaponizing this law, one must remember that the UAPA was made even worse by the previous government. No one is a saint, no political party is a saint. Everyone wants this law on the books for their own convenience. That is the other side to it.
Hi Chitranshul, very interesting talk. I don't know anything about law and legality, but I wanted to ask, is this sedition law not in sort of opposition, or can there not be an argument made about it sort of impeding on the freedom of speech, right? Because it does quash a lot of freedom of speech, right? So what are your views on that, and how does it sort of work out in terms
It
of...
definitely is a restriction, because like I said, the law itself does not provide that it can only be applied when there's violence. Why can't someone criticize the government or try to create disloyalty, disaffection? The citizenry of this country is mature. They can take a call whether they want to support the government, they don't want to support the government. It has to be removed. It has to be completely repealed.
So if you repeal, let's say that Supreme Court constitutes 7 judges, quashes it, and you have UAPA, what would be the purpose of this exercise? Because, I mean, Omar Khalid's case is quite the best example. So if you can prosecute under UAPA, how does it matter whether you're prosecuting under 124A or not?
This is a discussion that we had internally when we were filing all this, we were drafting all this. This is actually what I asked people I was working with, that so what they called it unconstitutional, UAPA still exists. The answer from legal minds wiser than me was one battle at a time. They said, let's first go for the low-hanging fruit, then we'll go for UAPA.
Hi. So you said 124A says on the basis of public order, you can file a sedition.
124A doesn't say that.
But
The Supreme Court says that.
Supreme Court says
Yes.
that. But what public order is
It's not defined anywhere.
But freedom of speech and expression is also restricted based on
Public order.
right?
Yeah.
So has the court interpreted that?
No.
No.
So Kedarnath Singh doesn't lay down what actually would constitute public disorder in that sense. Like, from a layman's perspective, you can, like I said, even someone vandalizing a park is public disorder. But will it be elevated to an act of against the state? No. So there has to be, if the Supreme Court doesn't want to declare it unconstitutional, still wants to protect it, and they want to water down the law, then in that case some doctrine has to be laid down to interpret what public order, public disorder actually means. Has to be done.
Hi, Chitranshul, I just have one question. Actually, it has 2 parts. A is, UAPA is a special legislation. Special legislation prevails over general legislation. So now, if you are saying if we go for 124 first, and by principle, if there is an order passed on 124, we will take that and then use that to sort of get some relief under the UAPA. But I just want to understand why not go for the UAPA first, because general legislation will last no matter what. Why take the general legislation and then go for the special when?
It will be the same answer. No, it will be the same answer that I just gave. It's just one battle at a time situation. Like, there are people who want to challenge UAPA in one go, but then civil society as a group needs to focus on the battle. It can't be staggered. It can't be like, you can't be shooting in 4 places at a time. It needs to be focused. The challenge needs to be focused. So go for one thing first. It's always the prudent thing to do. Like, I know it sounds very nice to be adventurous and say let's go for UAPA also, but it may not succeed.
No, but 124 will, I mean, that's from where I'm coming from, that's your general legislation, let's say that's the substantive law. So why go for that? Because it's from where I'm coming from, it seems harder to get the substantive law than attack the special legislation.
So from where I stand, I only see 2 options. Either go for 124A alone or go for both. You can't do an either or here. That's the thing.
So you said that citizens need to advocate. So can you give us 2 or 3 examples of, if as a citizen I have 90 minutes to spare, what is a non-seditious, productive way in which I can advocate for the repeal?
There's a criminal lawyer right next to you. She'll protect you. No, see.
I was going to tell you there's no time.
No, you have to write to your MPs. You have to speak to people around you who may not really understand the law. I know it sounds very idealistic, but something has to be done. If you have that capability, or you have that, you write for newspapers, keep saying that this law needs to go. But the best way, like there were two MPs, D. Raja and Shashi Tharoor, who brought in private member bills to repeal 124A. Private member bills die a quick death. Nobody takes them seriously. But they didn't do that. They tried to create a conversation around it. So conversation around it has to be created. Like, it's not as if that only the minorities or marginalized people are being affected by it. Today they are being affected by it. Tomorrow it could be anyone. So for that conversation has to be created.
So very intrigued by the comment you made about representation on the bench. What do you speculate would happen if there was equal representation on the bench in terms of caste, gender, sexuality? How would it be different?
So this is a commission, not a bench. So it's a committee. It's not in court. And what will happen with representation is that diverse views will be presented. Till you don't have diversity in views, diversity in recommendations, you will not get a law which works for everyone. Because certain laws work unequally for people. Even though law is supposed to be equal for everyone, it works unequally for people. Until that representation is not there, these concerns will not be raised. The court said that that merely because there is a chance for a law to be abused does not make it unconstitutional per se. So that chance for abuse has to be fortified. You have to show that it's actually not a chance to be abused. It's a real threat that abuse is happening. Until the time tribal activists, rights activists, minorities, oppressed castes don't get into these committees, women don't get into these committees and point out where it is going wrong, it's not going to happen.
So ultimate goal in that scenario will also be that the committee decides to, even with equal
Committee decides to
reappeal the law and sort of take it down, basically.
Yes, maybe. Maybe an outcome of that.
Chitranshul, this was very beautifully, you set out the history of the law very beautifully, and thanks for that. I was just wondering, based on how you described it, it seems that the law is getting stricter by the year. I wonder if really petitioning against it is the solution. Because it just seems like there's a strong argument, and I don't understand that argument. I wonder if you can expand on that, for retaining it or making it stricter as the years go. Would you have any sense in your research?
What do you mean by that, retaining to make it stricter?
The reason why the law is getting stricter, is there a strong argument that is being posed for that? Maybe attacking that would be easier.
But where do you attack that?
But is there such an argument at all that is being made? Keep the law more rigid, more stringent.
I personally have only seen such arguments to be made from one side of the political spectrum. And a lot of people don't even like to talk about it. A lot of people don't even like to, like one of my friends, when I wrote this book, he's also an AOR in the Supreme Court. He came up to me like, boss, I hope your taxes are in order. Yeah, she said that, I hope your taxes are in order. Because a lot of people feel that it's a very uncomfortable conversation to be had. Even making such a suggestion can get you branded as an anti-national on social media. And that term creeped into an order of the court when Kanhaiya Kumar was being granted bail. Justice Pratibha Rani actually said that one of the conditions of this bail is that he will not indulge in any anti-national activities. But where is that anti-national activity defined? It's not defined anywhere. So when he started making political speeches after, Delhi police again approached the High Court. Thankfully, the judge had changed by then. Said cancel his bail, it's all anti-national activity. So even getting into that conversation is difficult for a lot of people. So the only forum that remains is the court. In fact, I don't want to suggest anything else because you never know. Alok is tweeting saying anti-national comments being made.
Alright, I'm so sorry if you have more questions, please continue the discussion outside over refreshments, but we've run out of time. So thank you so much, Chitranshul, for the talk.